Today's discussion is on the recent judgment of Justice Bela Trivedi and Justice Pankaj Mithal on whether or not the services that are rendered by a lawyer can be bought under the purview of definition of services under Consumer Protection Act. It's a very interesting case where there is a small check bounce that takes place. Now, the client of a said lawyer approaches him and says that you please file a 138 petition in this. The case is filed and the accused agrees to provide for 20,000 rupee check bounce amount and also some 5,000 rupees towards the expenses. The lawyer says that because this 5,000 rupees has come towards the expenses, I should be provided those because that's the expense that I have incurred. And therefore, when the complainant does not provide the cash that he was asking for, the lawyer files a civil suit of recovery against the complainant. Now, the complainant, when he receives the 20,000 rupee draft which was to be given, he does not receive that 5,000 rupees that was to be given to him towards the expenses incurred. This happens because the lawyer tells the accused person to not make that payment and therefore the check is stopped. Pursuant to this, the complainant approaches the district forum and says that I should be given some amount towards the mental agony, compensation and such like. So there is some certain amount that he says that I should be claiming from the lawyer because there is a deficiency of service that takes place. Now, the lawyer files his reply and says that there is no maintainability as far as the district forum is concerned. The district forum says that no, I have this complaint is maintainable and passes an order against the lawyer. The lawyer then approaches the state commission and there the state commission says that the services which are rendered by the lawyer cannot be considered as services under the definition from Consumer Protection Act and therefore reverses the judgment given by the district forum. The complainant then goes to the National Commission in revision petition and there the NCDRC, the Honorable NCDRC holds that in any way this definition of services has a wide scope and therefore the services rendered by the advocate can come under the purview. The matter then travels to the Supreme Court and this is where the arguments take place. Different bar councils are represented. There are different bar associations who are represented and then there is Mr. V. Giri who's appointed as the amicus in this matter and there are catena of senior advocates who present their arguments. Let's now look at what the submissions were. The various submissions that were provided by the learned senior advocates included one, that the Advocates Act itself is a very comprehensive statute and it provides for disciplinary action against the advocates. The Advocates Act 1961 provides for a complete mechanism for redressal. Secondly, as far as legal profession is concerned, this is a profession which is called as a noble profession, and also that a lawyer is not only duty bound to the client but he or she is also the officer of the court. They are also bound not only by court but to their opponent. They have a duty towards their opponent, they have a duty towards their colleague at bar and also towards client. So it is not just one person that they are liable. The other major argument that we see is that since law as a profession is a noble profession, there is a code of conduct which is there and that it is not a business or a trade, and so they have the bar councils have very specific redressal mechanisms. There are disciplinary actions that can be instituted against the advocate, by virtue of which, if found guilty, that person can even lose their license to practice. There is also, most importantly, another aspect which is observed by the Honorable Court, which is that Advocates Act is a special law, and therefore it will always be over and above the Consumer Protection Act. It will always supersede the Consumer Protection Act. And lastly, the profession is adversarial in nature. If you allow the advocates to come under Consumer Protection Act, what will happen is that it will open up a floodgate of litigations that will take place, and there will be so many of these vexatious litigation that will come up. And there will also be an entire burden on the judiciary to adjudicate upon matters. There will be multiple forums, multiple kind of orders that will come, which will be conflicting, and it will just basically create a lot of problem for the judicial structure itself. Also, the other argument was that law as a profession is an enabler to the judiciary, and therefore lawyers are completely ensuring that democracy in some senses is moving forward and that it is being respected. It was also said that medical profession, there are some scientific measures or scientific standards which are there, basis which one can notice what could have gone wrong. But as far as lawyers are concerned, this is an area where there is nothing which is scientific in nature. Everything is very it's open to nothing being completely concrete. An opposing counsel can come with another strategy, you can have a different strategy, and so therefore whosoever wins would have multiple things that may or may not have worked for him. Therefore, to say that it is very conclusive in nature, that it is very predictable in nature, is wrong. The analysis and therefore the finding of the Honorable Court on this matter can be largely clubbed into three areas. The first one being that if we look at the intention of Consumer Protection Act 1986 or the reenactment that took place in 2019, there is not even a whisper of bringing professionals under the definition of services that is provided. So therefore, you do not find any medical professionals or lawyers being named as far as professionals are concerned or the services that are rendered by them. The only essence that we see of these reenactments is that it is always to ensure that if there is any unfair trade practice that is taking place, the consumers are protected. The second most important analysis that takes place is whether or not legal profession can be called as sui generis. That is, can it be equated with other professionals? Can it be equated with other professions? And whether or not it is something that comes at par with traditional professions? The answer is no. Law is a noble profession and it is completely different from any other profession. Therefore, there are rules, there are codes of conduct, and there are different other areas from where grievance redressal can be done. So therefore, to say that no, legal profession is just like any other profession will be incorrect. It is important to note here that legal profession has a specific role as far as justice delivery system is concerned. The last and the most important analysis that is conducted is that there is an analysis of the advocate-client relationship. Now we know that advocates have fiduciary duty towards their client, which essentially means that if tomorrow as a lawyer I'm making any concession or making any undertaking on behalf of my client, it is only upon the instructions of client. So anything that a lawyer does is primarily on the instructions of the client. Now that essentially means that the client has a lot of control over their own lawyers or advocates, which means that they have a say into whatever submissions are being made or whatever concessions are being made in the court. As a result of this finding, there was a final finding which was given by the Honorable Court where they said that the advocates provide services which are in nature of contract of personal services, which is an exception as far as the definition of services is concerned, and therefore the advocates do not come under the purview of deficiency of service. I hope you find the information that I've provided useful, and if you have any queries, please feel free to write to me. Thank you so much for watching. Have a great day.